what I do right now, what I'm focusing on personally at this time, is not long ago, because we were only in the area of family law, there was a desire to move into other areas of civil practice. So I became involved in the civil committee of the ICP, and was, wanting to see how that would work, how it would grow, how could you make the same thing happen in those areas. The civil practice could pretty much cover any area. We identified about 25 areas of civil law that were potential or viable as places that you could use collaborative law. That has been pulled down a little bit more to a focus on probate, estate planning, which are really together, contracts, construction, employment, medical era, institutions like religious institutions. I just had an experience recently where I worked with a church group that was dividing up, and we use collaborative techniques on that. But it doesn't seem to have any boundaries. There's always a way to figure out how you can make it work. And I have a real good friend in Texas by the name of Sherry Abney, and she wrote a book on civil collaborative practice. Her little motto, I guess, or philosophy is just don't go to court. Use any technique that you can not to go to court, because that's where you lose control. That's where the court starts having the say in everything, and people no longer have any ability to shape their own life. There's this thing I learned in my first training. I'm going to show you this. A client comes in, and they bring in everything that they believe is going to be meaningful in their life as far as what's going to go on in court and litigation. So they're able to leave about this much in your office that day. You peruse it, study it. You get it down to about this much. In family law, we have an initial hearing to just, find out what's going to go on a temporary basis. So this is what you take to court with you. This is what you're able to present in that initial hearing. Go back to your office, peruse a little more, getting ready for trial. This is what you're able to take to trial with you. You gather together to get ready to go to court. This is your trial file that you're going to present. Go in. You get to present about this much. So then, if I can roll this again, about this much is what the judge or jury take with them to consider all of the issues in this family's life. They're going to base all of their decisions on this much information out of everything that they had to bring to the table. It's, kind of goes back to that stupid thing. It just visually shows people that they don't want to go there. Where I am right now, though, I've been working toward becoming an exclusive collaborative law practitioner. I achieved that goal about 3 years ago. I have so much business, I don't need to really do much marketing or soliciting. I'm very fortunate. I do guardian work, and I'm a mediator. I am the current president of the Georgia Mediators Association. I am also trained and certified as a parent coordinator. Parent coordination is when you work with high conflict parents in cases. Typically they are, the parties are ordered by the court to go work with a parent coordinator to help reduce the conflict. So it can be very draining, as guardian work can as well, but those are my two purviews into anything that has to do with the court pretty much. I don't go to court anymore. I work in my office and see my clients there. The other thing that I have is a business. It's called the Collaborative Law Training Associates. And I go all around the country and do training. It's interdisciplinary training. So Sherry Abney is coming here in September, and we are going to put on what is the first, as far as we know, comprehensive collaborative law training. Very exciting. I mean, we're still in the process of developing it, but the first day is going to be generic. It's going to be presentations on all of the areas that everybody needs to know about. First of all, everybody needs to know about the paradigm shift that they have to make in order to be effective in collaborative law. For the lawyer, it's moving from being an adversary to being an advocate. For the mental health people, it's moving from being a therapist to being a coach. And, not being focused on things that are in the past, but being focused on things that are in the here and now that need to be addressed in order for people to move forward. For the financial person, it is moving from being aligned with one side or the other to being a neutral. They have to look at the process. They can't look at what's going to be best for the husband or wife. They look at what's going to be best for the family. And for the mediator, it is moving from being just a neutral to being more of a facilitator. We're also in this training really digging deeply into developing more roles for mediators. In some of the areas around the country, unfortunately, when collaborative law came in, it set up a competition almost between the mediators and the collaborative law professionals, which was never supposed to be the intent, because they're using the same skills. So it's much better if you use the mediators in the community and incorporate them into the collaborative process. So we're finding better ways to do that. We did a training in Michigan, which is where Zima Zameta is, which is one of the big trainers in mediation. And we coined a type of practice there, which was mediation facilitated collaborative law. And they have mediators in Ann Arbor in all of their cases. So our thought is always the community needs to evolve and define, what they need. My personal philosophy as far as working with clients is you need to learn to be a good diagnostician. And you need to learn, what do they need? What do they need? They may only need 2 lawyers. They may need a whole team. They may need a whole team but can't really afford it. So you balance that need that they have for services with a realistic financial ability to pay for those services. And I think you get the best result. Also, by doing that, you open up opportunity for diversity, because there are a lot of people that could benefit from collaborative law, but they can't afford, one of the, what I'd call a high-end, full-team type of case.